just follow up on Beth's comment that reforms of Section 02, Section 702 are needed in order for it to be reauthorized, and maybe illustrate some of the reasons why that's so true. And let me begin with a question for the group. How many of us have ever donated to a political campaign, a congressional campaign specifically? Probably everybody in the room multiple times. Well, you may be glad to know, if you've ever done that according to a recent disclosure from the intelligence community, your contribution to that congressperson may well have resulted in the FBI's spying on you and 19,000 other contributors without a warrant, using this massive database of information that's been collected pursuant to Section 702. And as Beth mentioned, is supposed to be focused on foreign threats and foreign persons. Recent disclosures also show that this database was used in 2021 to conduct 3.4 million warrantless searches of Americans' communications. And even after an effort by the FBI to shape up for this reauthorization debate in 2022, the FBI still used that database to conduct more than 200,000 such warrantless searches. And the FBI itself admits that at least 8,000 of those 200,000 searches were non-compliant with the FBI's own stated standards. And those included searches directed at least one Republican House member, a U.S. senator, a state senator, a judge, and a lot of people's girlfriends, and a lot of other people. And through this Section 702 database and through other means, today the executive branch conducts surveillance on our own citizens on a scale that would have been unimaginable to those who wrote and ratified Articles 1 and 2 of our Constitution, and who wrote and ratified the Fourth Amendment in the years between 1787 and 1791. And in that regard, I think it's important to distinguish between surveillance of foreign persons and surveillance of American citizens, which are on, I believe, a very, very different constitutional footing. But the challenge that we have is that the modern surveillance state is directed in substantial part at American citizens, and not foreign persons as well, but in substantial part against American citizens. And it's not just the Section 702 database. There are actually 4 broad categories of surveillance of Americans today in the U.S. Besides 702, a second type of surveillance is conducted under a different provision of FISA, which Beth mentioned earlier, Title I. That at least requires a warrant, and that's the authority that was later found to have been misused in the surveillance of several members of the Trump, who knows how many members of the Trump transition team in 2016, but including my client, Carter Page. And that provision nominally requires probable cause to believe that an American is acting as an agent of a foreign power, but it's been well established now that in the case of Carter Page, because of the present lack of any real adversarial process in the secret FISA court that was mentioned earlier, the FBI was able to get 4 warrants against Carter Page based on weak and to some extent even fabricated evidence that never would have passed muster in a normal court. The third mechanism for surveillance of U.S. citizens is Section 2.3 of Executive Order 12-333, which is not based on any underlying statute, but it allows the intelligence community to spy on Americans' texts and emails and browsing history and anything else stored in the cloud, again without a warrant. And the fourth mechanism, which currently is completely unregulated, is government purchases of our data. And these purchases allow spying on Americans' most sensitive information of all kinds, including our location, our internet activity, and again, all without a warrant. Well, fortunately, the upcoming expiration of Section 702 provides an opportunity for Congress to reconsider and I hope rein in this entire massive multi-pronged system for spying on our fellow citizens. As you can imagine, the FBI and other elements of the intelligence community are demanding what they call a clean reauthorization with no added guardrails of Section 702 or any of these other three systems of surveillance. But fortunately, as far as I can tell, just as there is zero support in Beth's agency, PCLOB, for a clean reauthorization of Section 702, as far as I can tell, there is zero support in Congress for a clean reauthorization of that authority. And so the real question at this point is this: if Section 702 is reauthorized, what are the conditions or the protections that should accompany that reauthorization? The organization that I represent and a number of other organizations on the political right and left and center believe that Section 702 should in fact be reauthorized, and for many of the reasons that have been discussed already, but that it should be done in a way that respects four specific principles. Number one, any surveillance of Americans should be undertaken only pursuant to a statute enacted by the people's representatives in the Article I branch, and not through executive orders or any other kind of self-appointed authority by an executive agency. Number two, Congress should recognize that Americans have a legitimate expectation of privacy in any electronic data that they have taken reasonable steps to protect, including password protection. And absent a genuine emergency and consistent with the Fourth Amendment, any government-related searches of our data that we've made an effort to protect should be undertaken only under the authority of a probable cause warrant. People in the intelligence community worry about whether that would be too burdensome. But if you take Beth's example of a phone found on a battlefield that has a 212 number in it, if the FBI goes to a court and asks for a warrant to do a search for that 212 number, they're going to get a warrant in an instant. And so I think the concerns about the difficulty of the warrant requirement are vastly overblown. And of course, we operate with warrants in many aspects of our legal system anyway. Number three is that agencies should not be allowed to buy their way around the Fourth Amendment and other legitimate privacy protections by getting our personal information from data brokers. And number four, any surveillance of Americans should be subject to real oversight by Congress and the judiciary, thereby ensuring accountability for the exercise of whatever authorities are granted to the executive branch to surveil our own citizens. Fortunately, a substantial bipartisan, bicameral group of senators and congressmen just this week have introduced a bill that, in my view, satisfies all of these four principles. It's called the Government Surveillance Reform Act, and it's co-sponsored in the Senate by none other than our own beloved Senator Mike Lee on the Republican side, and by Senator Ron Wyden on the Democratic side, and several other senators in both parties. And in the House, where the bill has also been introduced, it's co-sponsored by House Judiciary Subcommittee Chair Andy Biggs and other prominent members of the House Freedom Caucus, along with several members of the House Progressive Caucus and a number of other more centrist House members. In fact, as you all know, it's rare to see such a wide variety of people on all parts of the political spectrum agreeing on something like this. If it passes, the GSRA will, I think, rein in our ballooning surveillance system in several ways. Number one, it will generally prohibit warrantless searches through any of the four mechanisms that I've mentioned earlier of Americans' personal information, including phone information, text and email communications, geolocation, web browsing, and internet search history. Now, the bill has reasonable exceptions for genuine emergencies, such as identifying malicious software and truly serious imminent threats. In addition, this bill will fully phase out surveillance under a provision of the Patriot Act that is almost dead. You remember the Princess Bride? It's called Section 215 of the Patriot Act, and it is almost dead, but it's not quite dead. And the GSRA will completely phase it out, and so that it can't come back to life. And that's a provision that gives the government warrantless access to business records, like all of our emails, stored at Google or or wherever, and any documents that we may have stored in the cloud on our Google Drive or Microsoft OneDrive or anything like that. Section 215 allows warrantless access to those materials in certain circumstances. This legislation will also require the appointment of civil liberties experts or amici to assist the secret FISA court in testing warrant requests in sensitive cases like the Carter Page case. And having gotten deeply into Carter Page's case now as his appellate counsel, I am virtually certain that the shenanigans that plagued the Carter Page investigation would not have happened if the people at the FBI had realized that there was a significant risk that somebody was going to catch them in the FISA court, and having an independent person there sort of advocating for privacy generally, I think would have deterred the kind of misconduct that we saw there and that has now been widely recognized. The legislation will also hold officials in the FBI and other intelligence agencies accountable for negligent or willful violations of the new legislation or FISA or other authorities, including, in egregious cases, firing them and stripping them of their security clearances. And one of the things that I've learned as I've talked to a lot of people about this issue is that what typically, the thing that FBI agents most fear if they get caught doing something inappropriate is that they would lose their security clearance, because that means they can no longer go to the private sector and make 4 or 5 times what they're making working for the government. And so, in order to have real accountability, you need to put people's security clearances at risk. Just to close, the GSRA already enjoys widespread bipartisan support because, in my view, it's the most balanced and comprehensive surveillance reform in 45 years. And perhaps most important, given the theme of our conference, if it passes, it will make major strides towards realigning the federal government's surveillance powers with the founders' vision of what our government should be. Thank you.